So welcome back, everyone. We are now resuming with the second panel of today's workshop dedicated to the interpretation as a tool in the normative development of international law. A very small housekeeping announcement. Unfortunately, due to some last-minute circumstances, our chair was not able to join us, so Dr. Apelin Koagnezo will not be able to join us today, and our primary investigator, Professor Panos Mercouris, has graciously taken on the role of chair of panel 2. So we will proceed in this way. Once again, for our online participants, welcome everyone. Welcome, Professor Çalı. I hope you can hear us well. Please notify us if there are any issues. And yeah, indeed, once again, you can use the Q&A section all throughout the panel to pose questions. And otherwise, we can start now. Welcome back, everyone.
Okay, so again, welcome back, everyone. So we're here for panel number 2, and the topic is CIL interpretation as a tool in the normative development of international law. So we're joined by an excellent panel of speakers. I'll follow my predecessor's practice, which has become customary international law. How many jokes does it become infuriating when we make about customary? Keep going, there's still more time. So we'll start with our speaker who's on screen, Professor Başak Çalı, who's a professor of international law at the Hertie School and co-director of the School Center for Fundamental Rights. She's an expert in international law institutions, international human rights law, and policy. Welcome. Then we'll deviate as well from the program, so I'll follow the way that our speakers have set. So then we'll be followed by Professor Luíza, Leão, Soares, Pereira from the University of Sheffield. She's a lecturer in international law there, and her research is focused on international lawyers as lawmakers and explores the role of the profession in the development of substantive rules of international law. Our third speaker is Robert Knox, who's a lecturer in law at the School of Law and Social Justice at the University of Liverpool. And Robert's research interests lie in the fields of legal theory, particularly critical and Marxist legal theory and public international law. And last but not least, we have Johannes Fahner, who's a postdoctoral researcher and lecturer affiliated with the Amsterdam Center for International Law at the University of Amsterdam. And he also is an attorney at law at Allen & Overy in Amsterdam. And his research focuses on international dispute settlement and on the interaction between international and domestic matters. For those of you who are online, the program also had Itamar Mann from the University of Haifa, but unfortunately, as Nina already mentioned, due to some personal issues, he was not able to attend. So having said that, I'll start with the questions. By now, you're all pretty much familiar with how this goes. So the panel is focused on the outward-looking bird's-eye perspective of how interpretation affects the development of international law generally. And the first question, is there a role for customary international law interpretation as a tool in, within brackets, domestic litigation? And if so, what are potential uses of interpretation in this regard? Apparently, if it is not, that's the end of the question. No is an answer and you're done. So, Professor Çalı.
Hi everyone. Hi Panos. I hope you can hear me okay, and you can see me okay. I see just some of the panelists, and it's just very delightful to be here online. Thank you very much for making me part of this conversation. So the way my answer to the first question, and I think probably the following questions would be shaped by a few initial considerations. So maybe I'll just put them on the table as I may be coming back to them as we go with the questions. And just a little disclaimer, maybe I don't have a child that will disrupt me in this session, but there's a puppy and somehow my neighbors are drilling this afternoon. So I will sometimes mute myself if they continue with this exciting housing project just next door. So what are my general sort of considerations when responding to these questions? And I wanted to just reflect on the previous panel as well. I was absolutely fascinated by sort of the more general discussions that we had in the first panel. And big words at the back of my mind is context, context, context. So I think you will see that this coming through in some of the responses. And I use the word context in different ways. It's legal context, it's institutional context, as well as normative context. So I have different ways of using the term because I think this really colors and affects the answers. So my first answer to your first question really focused on domestic litigation and the tool of domestic litigation. And in my answers, I really try to sort of underline this institutional and legal context of discussing interpretation of customary international law, that this would be very crucial in answering this question in one way or another. So with the institutional context, I went back to some of the standard discussions about the monist and the dualist states and their positioning vis-a-vis or their ability to actually use or invoke customary international law in the first place, and how much significance this could have, or whether they have enabling domestic legislation to actually reach out to customary international law because they are required to do so, or whether they're just doing it because, you know, they just want to show off their international law knowledge in the context of litigation. And of course, litigation context, whether they're pushed by litigators, by amicus briefs and so on, to consider customary international law. So I think all of these institutional contexts, legal opportunity structures, if you would like to use that term, really become crucial when we talk about whether this is a tool in development of international law. And I think we will find quite a lot of variation. So I would find it really hard to speak about this in the abstract, you know, in general. So I think it really depends. Where are we? Which country? What types of structures? What kinds of judicial culture? What kinds of litigation culture? What types of issues? The second aspect, I think, to my answer to this question really emphasizes the legal context. So what I mean by this is how long is the shadow of treaty law when domestic courts in particular you know, are considering questions around the interpretation of customary international law. And I do come to this obviously from fields that I know better, which would be international human rights law. And because you have a very dense treaty context in international human rights law, the role for discussions on customary international law would either be not very predominant, or even if they are, they will be really about incredibly specific non-ratified treaty or fine-tuning. So the interpretation space for customary international law is then significantly diminished if you have a big shadow of treaty obligations. And I think that we could maybe say this even beyond the use of international law by domestic courts, beyond international human rights law in other fields. So those would be my two brief responses to using CIL as a tool of domestic litigation, with a lot of emphasis on context, institutional, legal, and also maybe an emphasis on legal opportunity structures domestically.
Okay, thank you very much. So then let's follow up with Luíza.
Great. So in the tradition of not having responded to all of the questions, I would again use kind of context, I guess, to get out of that conundrum. I think there is a role for customary international law interpretation as a tool for litigation insofar as it allows for the exploration of the open-endedness of the law in a certain area under dispute, if we're talking about litigation, to, let's say, as counsel, if we're talking about litigation, pushing one argument over another. So I would say that this is how customary international law can be deployed as a tool in litigation. So as a tool by the litigator to further their client's interests or their client's legal argument in practice.
Okay.
Very brief.
No, Well, that's good. Being laconism is the philosophy, so being short and sorry, I'll move on from the ancient Greek. Robert.
Okay, so I think it's difficult to answer any of these questions without giving a small essay beforehand. I won't do that. But I think just one thing I want to bear in mind when thinking about this question is the idea that I would understand interpretation not simply as, or even primarily, a kind of internal legal matter, but also a way in which particular political struggles are translated into a legal form. And I think that's important because it does help us frame and fit what the role of customary international law and its interpretation might be in the context of a domestic legal struggle. Because the big question that we want to start off with asking is, well, why? Why would it be that actors or agents would tend to appeal to this, and in what context would they want to do it? In part, it's actually, as Luíza says, it's to buttress particular legal arguments. But I think very often what people are trying to do in this context is take advantage of a series of legal rules and legal arguments which are located outside and above the context of a particular domestic dispute. So let's say you're dealing with a legal regime where things seem very settled and they're settled in a way that is bad for you. Perhaps you appeal to the customary international legal interpretation as a way of circumventing or trumping that discussion, and at the same time invoking the kind of rhetorical authority of international law as this kind of like, oh my God, it's so great it stands above everyone, right? So in part, one of the reasons I think that it ends up being employed and deployed in these contexts is to escape those kind of things. So it's very useful to legitimate claims and also to escape claims, right? One of the big areas where I think that's quite effective, at least historically, is actually in terms of effects. So one of the things that happens a lot in the UK, say with the anti-war movement, is if you can invoke a customary interpretation, it's happened a lot in the context of, say, Iraq, of a particular war as being unlawful under customary international law, that can form a defense for forms of property damage or obstruction and criminal trespass by going, well, the thing is, insofar as international law can be understood as part of English law, this can be invoked as an illegality defense, right? So that is one big thing. Now, of course, that crucially depends upon the particular kind of juridical arrangement and the relationship between customary international law. So the big thing I think is defensive. I'm a little bit more skeptical about the degree to which it can be invoked in a way that is like development-y, normative-y, because I think, well, courts tend to foul on that. But equally, I think one thing that we ought to consider is how it goes the other way, right? That in many cases, states might use their international legal obligations, including their customary ones, to say, well, actually can't do this. So, oh, you think that we can do this, but actually it's not going to be possible for us to nationalize this, have this political program, whatever, because it goes against some of these supranational legal norms, which exist at a relatively alienated and isolated level from forms of domestic political debate. So that, I think, is the two-edged sword for how this works in the context of something like domestic litigation. The particular character, and I'll come back to that later, of customary international law as a body of law that is constituted in a certain kind of way, can give it both a rhetorical weight, but also a kind of legal strength for argument. But equally, that can be problematic in terms of trying to push things beyond that domestic level if state actors try to invoke their own interpretation of custom to stop stuff from happening. That's done. Sorry. I thought the pause was definitive enough.
Yeah. I saw you turning the page, and then I said, "Oh, there's got to be more."
I was being efficient for question 2.
Fair enough. And then let's conclude with Johannes.
Yes, thanks a lot, panels. So the first time I read the question, is there a role for CIL interpretation as a tool in domestic litigation? My answer was very brief as well. I thought yes. Of course there is, if parties have a certain interest in arguing something that fits with a norm that could be derived from custom, of course, there is a reason to invoke it. It would maybe not be my first choice of finding an argument, but of course there may be reasons to invoke custom when, for instance, in the absence of written norms to the same effect. But then with some more reflection, I thought there are quite a few terms in this question actually that evoke a lot of other questions. In of course, the term interpretation, but also the term tool. And to start with the first one, interpretation, and maybe this goes a bit also back to the discussions we had this morning. We have discussed this distinction between interpretation and identification of a norm. And it seemed there was a lot of support for the idea that this is a bit of a circular or harmonious integrated process, whereas at least initially I thought of it more of a bit of a staged process where you have the identification of the norm or the rule first, and then, if necessary, the interpretation of it. And of course, this is different with treaties where there may often not be so much of a reason to debate or question the existence of the rule, but only the interpretation, although of course it may happen with treaties as well, but much less, I think. So since we focus on interpretation today, I was thinking, okay, what are examples of situations where we really have strong debates before courts or tribunals about the interpretation of a norm of custom? And the one I discussed in my short paper for today is the minimum standard of treatment of aliens, which by now I think is fairly established as a rule of international custom. It means that a foreigner, a non-national in any country in the world is entitled to a certain minimum standard of treatment, independent of the content of domestic law. And that is the important, conceptual aspect of this norm, of course. Then what else it means is, of course, very questionable and debatable. And we see a lot of, there has been a lot of discussion about that in investment arbitration, in particular because there are some investment treaties that refer back to international custom and refer to this norm. So that also confirms, I think, very clearly what Başak mentioned as well, that of course, we're used to litigate with treaties. So it's very fortunate that there are some treaties that refer to custom. So we sort of get there anyway. Now the word tool, when do we need interpretation as a tool? I would say that, well, you could say this is always the case. We always need interpretation. Anything needs interpretation, but I think that is not entirely true. We heard a lot of Greek wisdom today, so I thought we should mention some Latin wisdom as well. There's a lot of maxims of treaty interpretation or interpretation in Latin. I won't speak or mention the Latin text, but there's this idea that what is clear doesn't need to be interpreted. Very controversial, and of course there's a lot to be said against it, but I think it points to a legitimate point that in some instances there's much more need for interpretation than in other cases. And I think this is the case when there is some degree of vagueness or ambiguity in the content of the rule that as such is agreed to exist. So the existence of the rule is relatively established, it's just the content, the meaning is uncertain. I think when do we need interpretation as a tool? I think if there is some degree of arguably legitimate disagreement. So we need it as a tool when there are different meanings that each have a certain degree of credibility. And then secondly, this is the case, I think, when parties have really something to gain from pushing for one of these competing interpretations. That I think is where we really need interpretation as a tool.
Thank you very much. So I think the overarching consensus is yes, right? Yes, but with quite a few caveats, either in English, ancient Greek, or Latin, it doesn't matter. I would have liked, because you mentioned a few issues, but I think if I try and pry into more details on that, I'm going to be stepping on question number 4. So in order not to deviate from the order that Nina has created, because she's glaring at me at this moment, and that's why I'm not making eye contact. The second question is there a role for customary international law interpretation as a tool for the critical legal discourse?
All right, so I found this question very vague, because I had to really think about whether I should assume a common understanding of what critical legal discourse is, or whether I should impose an interpretation of what I think is critical legal discourse. And as you see in my answer, I was undecided. So I said, well, it depends on what you mean by critical legal discourse. So, because I think this is a very broad church, and the philosophical underpinnings of how you identify yourself as part of a tradition of critical legal discourse is, I think, quite significant. In my answer, I try to make one distinction, though I don't think this is the only distinction to be made. And this is the question about whether someone identifies with, say, a feminist account. Let me just use one example of international law, with the view of reforming certain norms or proposing certain understandings. So whether there's this aim of as you called it in the rest of the paper, a progressive development aim is part of whatever the genre of discourse. And something that I also identified is that, somebody can say that they're interested in Marxism and international law, or third world approaches, or feminism, but it depends on what is really the focus of that interest, whether it's a more reform focused or a foundationalist interest, or a more of an anti-foundationalist interest, and really emphasizing the power of critique to disrupt, to question, to undermine certain sort of underpinning problems that are behind the law, or whether one sees law as just a continuation of politics, or whether it's the discourse sees it as a place where you can reform things. So I'm really saying big words here, but obviously this all relies on genuine discussions that we have about how we understand these things. So this concept of a tool, then, it really depends again on how some of these questions are answered, whether someone engages with critical legal discourse for a reform-oriented purpose, or for the purpose of critique, for disruption, to actually show the deep political issues that are at stake, and the law being a mask or a cover of these things. So we see that in the discussions. Also, I might refer to some of the literature in the third world, international law approaches, scholarship as well, but there is a little bit of a disagreement. What do we mean by tool? Sometimes scholars will say, yeah, the answer is yes, it's a tactic. This can be used as a tactic. We talk about human rights as a tactic, for example, in the third world scholarship, in how we engage with the questions. That doesn't mean that there's a foundationalist support for a liberal kind of understanding of human rights, but it could be a tactic to disrupt, to undermine, and so on and so forth. And for others, it could actually be quite a foundationalist commitment to use CIL. And we see it in some of the liberal feminist international law scholarship that says, let's talk about gender of customary international law. Let's really push for a positive agenda to say that gender equality is a norm of customary international law. So that really is part of the project. So the part of the project is to make assertions under customary international law that fits with some of the concerns of that critical legal discourse. So this is, I think, something that I would undermine. I think the notion of a tool, the answer is probably yes, but I think different scholars, and I'm looking forward to answers from the panel as well, their interpretation of the concept of tool would be very different. And I think there we need to really look at how foundationalist these discourses are, or whether they have more anti-foundationalist sort of views on why we engage with international law in the first place. Thank you.
If I may abuse my power as chair, you mentioned this idea of pushing and asserting customary international law in a different kind of frame. Would that be in the sense of kind of using interpretation and kind of saying that all these different approaches and viewpoints can inform an already existing rule of customary international law? Or that the idea is to prompt action so that there is state practice and opinion areas that steers us to a different direction, or a little bit of both?
I mean, I think a bit of both. I mean, I think we can say that some of the focus would be, okay, so there could be different layers, right? So in layer one, why are we not talking about, let's say, a certain norm as customary international law? That could be a central concern from a certain feminist approach to customary international law. So saying that there's enough social fact, as Adil called it, or evidence or empirical evidence, or conduct or views, that we should increase the conversation about customary international law on norm X, say gender equality, in this, or a norm of gender equality in that regard. So that could be just, increasing the space to talk about custom, right? So that's a very sort of an engaging way to do it. So it could, say, let's read the material to make this case, because some states may not be making it. Courts are biased, they're not looking to it. So we can stand alone as academics or critical legal scholars to actually create the space to talk about it in those terms. I think it could also be even perhaps deeper, maybe challenging who are the actors. And I think this is, something that we would see very prevalent in Upen Bakshi's work, for example, where he would emphasize, why are we looking at states and state practice? So some of the critical discourses would even go deeper into the sort of the components of interpretation of customary international law, looking at subaltern communities, those who do not have voices, indigenous peoples, and why their practices may not count, right? So it could go on very different levels of just looking at, the traditional components and opening up the space for more custom on areas of normative concern, or also deeply maybe engaging with, what are the interpretive components, what are the empirical material that we deal with it, or it can just be seen as, well, whatever needs to disrupt this, this very problematic story that we have in international law, that's fine. It's just like any other tactic that one needs to use to actually uncover existing inequalities in the deep structure of the system.
Thank you very much for the clarification. So, Dr. Pereira.
Thank you. I think I will voice a lot of what Professor Çalı actually has said, because I think she put it very well, that the first step that I kind of took when looking at the question of about there being a role for customary international law interpretation as a tool in critical legal discourse was first understand what was meant by critical legal discourse. I think I interpreted it as some form of adoption of the indeterminacy thesis, which, and then that takes me to why perhaps this question is on the table, as in why are we asking this question? Why was it not answered, perhaps authoritatively enough that we're here discussing it? And I believe that it's because the whole idea of custom is at odds perhaps with adopting an indeterminacy thesis itself. So questioning deep questions, serious questions about aspects of the doctrine of sources, such as what is the role of custom, how do we interpret custom, would be at odds with adopting the indeterminacy thesis itself. So this is why it perhaps wasn't addressed enough, and this is why we're discussing it here. Is it at odds, though, with the critical project itself? I think the question is not necessarily, especially if we take the word tool seriously in this question here. So if we think about custom or in customary international law interpretation, not necessarily as something written in stone, but as a tool to be deployed by members of, in my case, in the case of the kind of work that I do, members of the Invisible College of International Lawyers that are critical and engaged in the progressive causes, whatever that might mean. I think it is a tool. So even if we don't look at it as a source, we can still look at it as a tool. So in that way, I think that the question works. Professor Çalı used the word tactic. I think that's a very good way of translating the word tool, perhaps, in more critical terms. And again, can it be used as a tool? Yes. I think thinking of it as a tool rather than a source, perhaps if we're talking in critical terms, would allow us to kind of bypass some of these fundamental issues with taking customs seriously from the standpoint of the critical project. I think, and then custom then being deployed as that tool, as that tactic by individual lawyers in favor of progressive causes, whatever that may mean. And then the question is, and this is what we're kind of a spoiler about the later question is, if it can, then why doesn't it? And I think that that is kind of where the bigger structural issues, which is perhaps what Rob was going to talk about a bit more, but also the issues of composition of who these people are that are capable of employing these tools and what kind of interest they have in employing custom or any other source as a tool is where kind of the problem lies. So not in the tool, but in who is deploying that tool and why it doesn't get deployed as often as perhaps one would desire.
Thank you. So I see a pattern emerging of treating tool as a kind of a tactic/strategy aspect, which, as you said, spoilers for the next question. So, Dr. Knox.
I'm just going to open by saying you can't say tactics/strategy. They're very different things. We're in a whole article on it. Fair enough. But so I think in some ways I'll be echoing what people have already said, and I think one of the things like that Luíza was like hinting at too is that like we're all kind of chomping at a bit to get to the next question. Every question, the next one. It's all crescendoing, and then you're like, oh, do I start saying it now, or do I wait? Am I holding my powder dry? Very, very difficult. But so I share some of the ambiguity and ambivalence about saying the word critical, because critical can denote very different people doing very different things, and that can lead to different understandings about how things go. I think it's probably useful, as with Luíza, to start by saying probably the starting point we can think of is kind of like post-Koskiniemi, post-Kennedy, post-legal realism thing about the idea of the indeterminacy of law, and this idea that essentially, as I said earlier, what this then leads us to a second point, which is that interpretation is incredibly political because it's the way in which different actors secure their political ends and aims. But also importantly for this, right, and I think this is somewhere where maybe a lot of us on this panel might disagree with some people on the first panel, this perspective says everything is interpretation, like law is interpretation all the way down, because even the things that you think are stable are themselves based on like different contesting outcomes, different competing opinions, which stabilize in one way but might not stabilize. Like, who says what's vague? Like, something might be vague to me or vague to you. I might say it's vague because I don't want it to happen, but the other people might be like, no, it's very clear, right? So the basic kind of like that critical point that we can think of is this idea that law is both like legal interpretation characterizes the whole of the legal field, and that is fundamentally and irreducibly like forms of political contestation. So in one way, right, what that suggests is that interpretation is always a field and form of political struggle. But it's political struggle that takes the specific form of legal argument, which is one way why I think actually indeterminacy people can deal with custom, because custom is a specific form of legal argument in which indeterminacy plays out in distinct ways because of that particular legal form, which may or may not be good about custom. So partly then, right, that on one hand might make us think, well, we want to be a bit careful about talking about tool, because this is a field, it's not just a tool, it's where stuff is going on. Like, what does it mean to talk about it as being a tool when it is in fact the whole space in which this is going on? And I will return to that in a second. But the place that like, and this is where it's important to draw this line between different critical scholars, the place that might divide, right, is a certain kind of like post-Koskiniemi, post-Kennedy account like this might just then be, so if everything's indeterminate, then it's all woozy and hazy, and these people can say this and that. But of course, other critical traditions, the Marxist tradition, but also like third world tradition, international and other people say, well, just because the international law is indeterminate, it does not follow that it's unpredictable. It does not follow that it is not structured. It does not follow there are plans that we can observe, and that in fact, even though the law is indeterminate, it tends to like be certain people that win, and that's in part because of particular forms in which these legal arguments are playing out. So what might that mean in this context of customary international law interpretation, right? Well, I think one thing that might be quite interesting to think about is that if we hear people talk about customary international, right? It brings with it certain assumptions about how the world works. It's assumptions about the world is composed of states who have an international community. What the hell is that? I look around at the world and I'm not sure there's an international community composed of states, right? And it presupposes this fundamental idea that on some level states have forms of agreements they can make, right? That is a very distinct way of thinking about the world that many critical people would say, no, there's not an international community. There are groups of interest, power, or inside or outside of the state, and that is shaped in particular ways, right? So I thought interestingly, Johannes, when you mentioned the minimum standard of treatment, of course, the 12 response would be, now where did that come from? Well, it came from colonialism, unequal treaties, Libya being unable to nationalize its oil, and then we get to today, right? So some people will map out a certain kind of history of that interpretation in line with this broader set of questions. So what does that mean then for this idea of the idea of law as a tool or as a tactic? Well, when 1,000 years ago, when I was a child, I talked about international law being a mere tool, which is 2009, so young, happy. Part of that was meant to signal, right, that the way in which, and we'll get to this in the next two questions, but the way in which you avoid some of the political pitfalls of these particular forms is by treating this as a mere tool, like something that you can pick up and get rid of because you do not want to be over-invested in its logic, because that's what cuts you off at the thing, right? And that is why when we think of a tactic, the difference between a tactic and a strategy is a tactic is a thing you do, a strategy is a thing that structures the whole plan of what you're doing. So then, in that sense, right, and this will come up more in the next questions, this is what we might think about. International customary, the interpretation of customary international law is a political field, and it's interpretation all the way down. It's a political field that has very specific characteristics based on the characteristics of customary international law, which I think we'll all talk about a little bit more at length. And this idea of the tool then is what do you do with this that means that you don't end up just buying the whole story that customary international law tells about the world and falling foul of all its problems. And I think in the next few questions, I guess everyone will develop what that might look like a bit more, but that is how I would read this question. I'm going to turn my page.
Turn your page, yes. Yeah. So I think everybody's gearing up for the next two questions because everybody's finished their presentation saying, this goes to the next two questions. One point that I'd like to raise, I think we disagree on tactics versus strategy. We'll talk about it over terms. Johannes, yes. Feel free to respond also to the bashing and thrashing of the standard. The minimum standard.
Yeah, absolutely. I won't say anything about the interpretation of the words strategy or tactic. And generally in this question, I was planning to be a bit brief for reasons mentioned already by others as well, that the third question seems to be a bit of the controversial thing. But my answer was actually along the lines of what basically Luíza and Robert have been saying as well. I think why interpretation is relevant or interesting to critical legal discourse is to question or investigate who interprets, who are the actors that are actually given the authority, at least by the states or by other parties, to interpret it, and why would they opt for certain interpretations. So I think the interesting focus of today's workshop is that we try to look at interpretation as this practice where also power structures probably demonstrate themselves, which is a bit different, I think, from the discussion of how the rules come into being in the first place. So what is interesting, I think, about the minimum standard is that there are very different stories, narratives actually about how it emerged. An alternative story is that this is actually fundamentally a human rights norm, which, yeah, in the first place protects the rights of anyone, anywhere. Interestingly, irrespective of that debate, I think we now have that rule, or at least it is recognized in treaties, among different states from different parts of the world, which sort of moves the debate into a new territory, which is, okay, what does the minimum standard mean? Which I think is precisely a question of interpretation. So yeah, I think that's an example of an interesting case study to see who the actors are that are given the authority to then answer questions such as this one.
Okay, and now we move on to the interesting question. And you cannot back out of this now. You've built it up, so it's your fault at this point. So, can customary international law interpretation be employed as a tool for the pursuit, whichever way you understand tool, for the pursuit of normative developments or change in the international legal order? Floor is yours.
Okay, so I'd like to hear from everyone else first. So it's a bit of a suspense for me as well. So I think maybe my take on this question was not that can, but it has been used in this way. So I think it's not the can question, because we have examples of it. And of course, I've given examples from two different legal contexts. A lot of human rights lawyers have been caricaturized as droit-lomistes, not proper international lawyers, arguing whatever they see on the Universal Declaration as a CIL. And, there's been a lot of caricaturization of a lot of scholars in the 60s and 70s and 80s. I think less so these days because of, again, there's been quite a lot of treaty law on things that people have tried to argue as customary international law. So this is something that we do see very frequently in the field of international human rights law, because it still matters quite to those who would like to deepen or advance international human rights law. And we see that this also is very significant because in some fields, it's very important to get to those who don't have very specific treaty obligations. And I'm really speaking on human rights law context here. So this big work on death penalty and the discussions of the prohibition of death penalty, for example, is a place where quite a lot of people have tried to work and say that at least the visiting of the death penalty on pregnant women or juveniles should be considered as customary international law. And a huge movement of people have pushed this through to the old subcommission, the old Human Rights Commission, and subsequently to the General Assembly, precisely for the reason that not everyone has abolished it. So we have a lot of empirical examples of this, really specific focus on it. We also see this now in the field of the international law of the environment. And, with the Pulp Mills case of the duty to carry out an environmental impact assessment. And this always comes back to the question of, progressive movements, maybe working through a soft law document, a universal declaration, and then, trying to sort of use that to argue for customary international law on those grounds. The same with the 2008 Declaration on the Rights of Indigenous Peoples. But of course, there are huge resource constraints. So you have to have big movements, you have to have a lot of stakeholders, you have to, this is also a very intensive process. And a lot of people in the human rights movement would also critique these efforts. Is it really time well spent, to get these declarations and then trying to get all these resolutions out? So there's also a long-standing critique of this learned method of trying to use or create, shape CIL and then sort of power its interpretation. And obviously it's less difficult if you have normative progressive causes that are not very well supported. It doesn't have a good sort of network structure. If you go back to the politics of it, that not well founded organized groups are able to sort of lobby around and things like that. So there's also a big discrepancy about maybe if you go back to the question of can, and we see this a lot in discussions about holding multinational corporations accountable. So my reflection on it was, this is a model, this has been a learned model of, in particular, a lot of Western human rights organizations actually, get the declaration out and then sort of galvanize and, try to influence states to get to that, magical point of getting a GA declaration to call something customary international law. But I think we also have to think about what kind of resource intensive project it means and what it returns at the end of the day, this type of projects. And of course, maybe just as a quick note, these types of activities can be pursued by all forces, however you want to call them, progressive or non-progressive, or people's progressiveness are also very different concepts. So this type of modalities can also be then used by everyone else. And I think we also see these developments, in particular in the area of LGBTQI rights movements and changes of laws and things like that. So CIL is a funny thing. It can be used, obviously, in these formats by all types of actors. Yeah.
So to sum up, CIL is a magical thing and a funny thing as well. And we have changed. Luíza.
Great. So can customer international law interpretation be employed as a tool for normative developments or change? Again, like Professor Çalı mentioned, I think not only it can, but it has. I think we have several examples where customer international law has been used to push agendas one way or another, to change the law towards one side or another. I think that is not only possible, but it's kind of allowed by the very organization of international law itself as largely customary or very decentralized. And also in my specific case of what I look at, the role of and the type of work that the profession does, how the profession is organized. If you have law that is quite porous on one hand as a recognized source, and on the other hand, you have a profession that allows for the same individual to act, to wear a number of hats, to occupy a multiplicity of roles, or they can push, personal projects, individual projects into the law, whether they're progressive or not, that is a different question. I think the system itself and the profession, how the system allows for the profession to be practiced, allows for customer international law and its interpretation to be used as a tool for pushing certain normative developments. Then, as I said, the question is, are they going to be progressive developments or not? And in a way, if international law is porous, and if the profession allows for this multiplicity of roles to allow for individuals to push the law in a certain direction or another, why doesn't it get pushed to where progressives want it to be pushed? And I think that takes us then to the fourth question, which is the limits question, which again, I think is a fascinating one, because I think the tool is there, it exists, it is deployed in certain ways. But the question is, why doesn't it get deployed in the way that one expects it to as such?
I think I see a pattern in Luíza of bringing in the next questions. Robert, you're banned from alluding to the fourth question.
Well, that's going to be a real problem. That could be actually, one thing I wanted to ask both the first panel, but also you guys about this is, to what degree, do you think that means that some of this interpretation has to be in bad faith? As in, if you're a person that's by the way, universal state practice says that you can't make outlaw homosexuality.
Yeah.
Well, I'm sorry, look around at the world, definitively that is not universal state practice, but you're trying to make an argument that it's customary. So I think there's an interesting thing there about do actors making these kind of arguments and interpretation of customary international law have to be acting consciously in bad faith, because they are the normative development that breaks with the kind of endless custom thing that we had a long discussion about, right? So I wonder about that. Then on this question specifically, so part of my skepticism is just my skepticism of being an old Marxist man, is I don't like the word normative, because I'm always well, what do we mean by normative? Normativity, to me, at least to some degree, implies a substantial field of overlap, which I don't think politics quite works with. And instead, so what I'm more interested in thinking is in what ways has the interpretation of custom given certain political traditions which I think, to which I have some allegiance and which will hopefully stop us from all dying in like flames and war and all that kind of stuff. To what degree has customary international law provided them with resources in the interpretation thereof, right? And so I think we've already heard on one level, simply empirically, it is just true. Right? It's simply true that it's like, you can't make this argument that says it hasn't, because it clearly has. And indeed, what we might add to that on a very grand scale, right, is the degree to which when decolonization happened, decolonization was, again, quite bad fake things, being like, oh, it turns out it's customary international law that you shouldn't have colonies. I suspect that was news to quite a lot of people, but nonetheless, right, those arguments were deployed in that way. So I do think looking at the kind of emergence of the anti-colonial movement, its transformation into the projects around the Third World Movement, and how they relate to customary international law, gives us an idea about in what ways that has been useful, and a little bit of the limitations, which I'll just talk about specifically in non-broadly, right, and a little bit about those limitations, right? Because I think that's quite an interesting story about that relationship to customary international law. So the first thing that's interesting to note, right, is that of course the early moves of the anti-colonial movements were often couched, I think retrospectively, as being custom stuff, right? Where it's like, oh, this General Assembly resolution is actually evidence of custom. Now, I don't think that's what they were doing at the time, because of course their critique was precisely that customary international law as a structure was against them. It was custom that was formed without them being part of it. And it's so difficult to change customary international law through this because it presupposes, again, this model that states will all agree to like screw themselves over. It turns out that they won't. And so they had this kind of usage there of the General Assembly, which I would say is a kind of an ambivalent thing, right? Because I don't think that in their initial legal mobilizations, these movements were thinking we're changing custom. It was that ambivalent battle about what the legal status of General Assembly resolutions was, right? So this is in part then gives us a little bit of the setting of how these things can go out, which is that on the one hand there, I think there are structural features of custom, which I'll talk about in the fourth question, which might suggest that making certain forms of change are very difficult, right? And we know this because it's like custom has a drag. What happened before tends to have more of a weight, and it's very difficult to get a state to be like, yeah, that's true, the historic practice of what I'm doing is against my interests. So we have this kind of sense, right, where they were using what we can retrospectively interpret as customary stuff, but that's not how they were doing it. But it's telling, right? And I think this is the important thing about us thinking about to what degree can these normative developments happen and then later talking about limits. That customary argument comes to like bite them, because as soon as they make these more ambitious claims through stuff like the NIEO and all of these kind of things, right? That is when custom comes back with a vengeance to be like, no, like this is not custom. Like these states are disagreeing with you. It cannot be the case that this happens. And that is a huge part in essentially shutting down a particular legal project of the kind of anti-colonial Third World Movement, because suddenly they can't rely on this in that way. And I think that's where some of the customary stuff reasserts itself in that way. So it's clear on this front, clear empirically that customs can do some stuff, right? Because you'd be an idiot not to say that. Like you have to be like covering your eyes up and like singing to yourself. But the limits, which we'll talk about next, are important, and that is also partly to do, I think, with the specific form, again, that these kind of customary rules and interpretations thereof make. And I think also, importantly, to restate this weak question that we've talked about before repeatedly, it's also a question then of which actors are doing which interpretation of which custom at any given moment. I think we have a tendency, because we're lawyers, right, to imagine that what custom and action is if it reaches a court or an arbitration body. But mostly custom is like states asserting their positions in whatever negotiations that they're having. That is where interpretation tends to actually happen in international legal terms. So there's probably also an interesting question and shift about the shift in the mode in which custom makes itself manifest and realized, and the changing of actors that can then be involved in it, which would also come into this story. And it's telling the degree to which that happens basically after the death of a substantive political project, which was trying to remake the world, and the birth of the horrible time that we live in now.
And turn page. Perfect. Robert, don't think that I didn't notice that on 3 occasions you alluded to the fourth question. Johannes.
Yes, thanks. Instead, I will allude to the second question.
Excellent.
But for some good reasons, I think, hopefully, because I agree with what was said before, that of course we have examples of situations where the interpretation of customary international law has been used actually and efficiently, or at least effectively, to develop international law. But in light of the second question, really, I think it's still important to keep in mind who the actors were that were developing these interpretations and why. Now, I think, so I read the third question very much from an international court perspective. So my ideas about this also concern international adjudicatory bodies primarily. And one of the things that I was thinking about was, for instance, what we mean by the term development, actually. So I think that what is often the case is that we look at a certain development of international law in a particular field and express a certain evaluation of that, which may be very different in one field than in another field. So, for instance, it's very different, I think, when an arbitral tribunal in international investment law develops international law, customary international law, from when a human rights court does the same. And I think what's interesting is to try and step back a bit from these sort of normative contexts when they are specific to one specific field of international law, and see if we think that interpretation on a sort of more abstract level, to the extent that we can talk about it that way, is something we want or not. And there my answer is a bit more normative, maybe. I'm very hesitant, actually, in particular, when it comes to international courts generally, and whether they should have the authority to develop international law, in particular to interpretation. And that goes back a bit to what I said in the first, in response to the first question, that I think we are dealing with interpretation primarily when there is some extent of legitimate disagreement about what a certain rule means. Now, if that's the case, I think it's a very big question whether international courts should have the authority to push the law into a certain direction, especially if we see that there is disagreement within states or within international communities of all sorts. I don't think they are generally precisely, and of course this is a huge debate in domestic law as well, I think, but I think the questions in international law are more problematic even for several reasons, and the most important one probably being that most international courts have some sort of specialized sectoral character. So they are established to interpret the law, that's true, but to settle disputes within a specific field of international law, be it trade law, be it investment law. So I would be hesitant to empower these courts with a specific background, specific expertise to solve more general questions of how the law should be developed.
Johannes, just a clarification, if I may. You said that you're wondering if there is a legitimate disagreement on how to deliver a particular rule of customary international, whether we should give the courts the authority to push in a particular direction. Wouldn't that happen in a case of a legal dispute? Wouldn't that happen by definition? Either go with one side, the other, or choose their own?
I don't think so. To some extent, maybe any dispute is about interpretation, but I think to more, to different degrees. So I think there may be a lot of disputes that are actually that don't turn on questions of interpretations, that don't turn on what a specific norm actually means, but rather how it should be applied in a specific factual context. And of course, that's like a spectrum, absolutely, but the sort of what I would maybe call interpretive disputes really, I think would be about, really the question of what a specific rule means in a sort of more general way, where it's clear that and for treaty interpretation, I guess this is a bit more easier to establish maybe, that there are really valid but contradictory claims to what the norm means. And in that sort of situation, I would be hesitant to yield the power to choose one of several competing interpretations over another two international courts.
Fair. Okay, so I was almost happy that we were reaching the fourth question, because then nobody could suggest I'm hinting at the fifth question, but Johannes flipped the script and he said, I'm going back to number 2. So there's no salvation, so let's go on with the fourth question. What are the potential limits of this mode of thinking about CIL interpretation? Çalı.
Okay, so the question says, right, this mode of thinking. So just to remind everyone, this mode of thinking is as a tool for the pursuit of normative development or change, right? So this is kind of the question, just to go back to, if not everyone knows what the third famous question was. I mean, I think there are lots of interpretive questions, right, in trying to unpick what these limits may be. And one aspect of it is, of course, going back to how we understand custom to be, how slow custom is understood. What is the relationship of interpretation of custom over time, or how much we understand and interpret certain types of facts in a more of an expedited process. And I think this question of time and interpretation has always been crucial. And of course, I think we have also these very fundamental disagreements about what exactly the purpose of custom is. So I think when you're trying to use it as a normative tool, you have some very friendly audiences who would be very receptive to it, and others who would actually take a lot more of a conservative view and really exclude or have actually you might end up having a backlash of trying to run a progressive argument through customary international law, or you may even consolidate certain types of interpretation because you pushed an audience too far. So I think it has just really interesting consequences, or it has interesting limits, because it could also make the interpreters of custom a lot more cautious, if you see what I mean. So the proposals of interpretation might actually get very timid responses as well. But I think here again, the context, the legal context and normative limitations are very much related. And I keep on thinking about, when there is no treaty law in a certain area, and I can't really imagine, maybe some of you are more imaginative, that, we're in this empty quarter kind of a situation and we're trying to, talk about customary international law. I don't think this is mostly where we are any longer. Either where we're talking about contexts where there are deep disagreements about interpretation of treaty law, and this came out a lot in the first panel on the use of force, for example, related questions, or where we have quite a lot of treaty law and a few outliers who are not part of systems. So I think these legal contexts are also capable of generating very different normative limitations of using CIL progressively or not progressively. As you have seen, I can't imagine talking about CIL without treaties. So this is something that I find it very, very hard to think about, and the relationship between CIL interpretation and things that we already have as norms in some global form or shape, or some regional form or shape. So I think the normative limitations turn to questions about location. So who is it that we're pushing? Is it the European Court of Human Rights? Is it the Inter-American Court? And I've given those two examples in my brief answers because it doesn't seem to have a lot of limitations when you're at the Inter-American Court of Human Rights to run customary international law arguments. But you have a very different response from the European Court of Human Rights making similar arguments. So again, a very broad answer, I think, to a broad question.
Broad is always good because it gives the audience as well chance to ask further questions about apparently the question that everybody's interested in. So, Lisa.
Okay, I no longer have that way out.
Nope.
No, but I also don't want it because I think that I kind of interpreted the last question as as you said before, like a crescendo from the previous one. So I'm reading it more in the context of us talking about customary international law being used as a tool specifically by progressives, right? So we talked about it before as in, this is the way in which custom and its interpretation can be used as a tool in critical legal discourse, and for normative development that I interpreted it as normative development that is progressive in nature. So in other words, rather than not answering the last question, I rewrote it, Nina. I hope that's okay. As what are the potential limits of individual members of the profession, which is my area of work, pushing progressive causes through customary international law and its interpretation. So what are the limitations for this idea that, yes, customary international law and in TRICI-Law's proposition, its interpretation can be used as a tool in our argument for the purposes of this panel for progressive normative development. So to push international law towards progress, whatever that means, towards the left, etc. So I would argue that the limits to that kind of lie, first of all, in contingency. So I'm talking specifically about the role of agency, right? So individual agents, individual members of the profession as critical people. The first limit that they face is that, of course, they're not acting in a vacuum, right? Like they are the profession, but there's also structure around them that moves international law one way or another, that shapes international law. So they're doing this in constant negotiation with other very powerful actors. International law, we're talking about states, of course, primarily. So the first limit would be states, would be the structural biases of the institutions from which they're working within. So they're having to deal with, the ICJ. When you're talking about normative development here, you're talking about the law that binds states, right? So necessarily the subjects, the kind of dispute that comes to someone at the ICJ as a potential progressive would be between states. Therefore, limitation on, for example, the role of customary international law towards pushing progressive causes for like indigenous populations, because there are gaps, and then whether they're deliberate or not is in the structure of is that embedded in the international law itself, or is it by chance? Then we can argue about that. But I would say the first limit is the idea that they're not alone. That as a individual international lawyer acting as a progressive in a fragmented profession within a fragmented system where there are gaps that can be worked around and within and filled by progressive causes, you're not alone in doing that. So this isn't an individual acting alone in the vacuum. We're dealing with a lot of other actors that have their own interests that might go against that. So that would be the first kind of obvious limit, I would say. Then I would say the second obvious limit is something that Professor Çalı mentioned, I think, in her first answer to the first question, which was what is considered progressive, right? And I think that came through a lot in my own research when I was looking at the role of certain individual members of the profession in pushing for certain normative, very, very narrow normative developments. If I think, for example, about Antonio Cassese pushing for the broadening of the regulation of non-international armed conflict on behalf of the project of humanity, right, in international law. So sure, that is, and I believe he conceived himself within the very extensive reading of a lot of his writing, and there's so much of it, was, I'm doing this in favor of humanity, in favor of this idea of international law progressing against states that have, their interests and that are powerful towards individuals, protecting individuals. But then at the same time, is that a progressive cause in the sense that, is it a progressive cause to then fuel, create, perpetuate a structure that is carceral? Is it actually making a difference for deterrence of crimes against humanity, war crimes on the ground, and all of these other things? So what is progressive in itself is up for debate and is shaped by that particular individual's experiences of what progressive means, and that has intended or unintended consequences in the real world as well. So I think that's the second limit. The third limit, I think it goes to the who, which was that kind of very obscure question asked in the first panel. And I think that the final limit I can see in customary international law being used and its interpretation being used as a tool by individuals for progressive normative development in international law in line with a critical project, whatever that might mean, is the who are the people that are undertaking these jobs, right? So we know that this is allowed, or that this happens because the system is, or the law is porous, and two, the profession is decentralized, so it allows for someone to be at the ILC one day and the ICJ the next day, citing their ILC work as if it were work that exists in the ether, and that is rubber stamped by a UN organ, but actually if they were the special rapporteur for that thing, they also have, you know, a role to play in that. So that would in itself allow for, you know, it be an avenue for these progressive causes to come into the law. But then who are the actors, or who are the individuals that get to speak, right? And this is like, who gets to speak, who not only who gets to speak, but who is heard, who is the profession, who are the individuals that make up these bodies. And I think this is where kind of the structure and agency, a big problem with the structure and agency conundrum and argument, which is that, yes, sure, these individuals have a degree within the realm, within the very strong limits that states, the existence of states, the negotiation with all of these other organs, etc. All of that is happening, but then at the same time, these individuals themselves are a product of their intersectional identities, of their conceptions of what international law is, of where they come from. Are they, you know, white men of the developed world? The answer is yes. What does that mean? I would say that means another way in which structure permeates and comes to assert itself again, other than the structure itself. The individuals are products of their own structural biases. So I think that it's the kind of where the circle kind of, you know, is completed. So possibilities, yes, limits many. I think that's my answer.
Yeah, and I think the last one, if you extend it also, which was also a little bit one of your first limits about the institutions and also the interplay between the institutions. Walter and Tariq also mentioned it in the first panel. The Gaffi-Governor de Maros case is very easy, a classical example, because the court referred to some draft versions of the Hospital State Responsibility, and afterwards the ILC used
and counsel was James Crawford for, which one was he counsel for? But he put forward one of the arguments, and he was counsel for one of the parties as well. So there's like a big web of cross citation and how authority is built within that community, and then what gets accepted and what doesn't, right? It's also a product of that. So I think it's very complex.
So tangled web, if we're to summarize, Robert.
So I think I'll just be following on more abstractly from what's already been said. And obviously I've already talked a little bit about what I think some of the limits of this are, because I just kept on referring to this question early. But I think there are some specific ways that we might conceptualize this. So I think the first point when we're thinking about limits and effectiveness, and I thought you put this really well, but I'm just going to like take a step back a little bit further from it, is effectiveness isn't just about did you achieve this objective or did you not achieve this objective. There's also a big question about like how did you do it? And in so doing, what subjects have you produced? What agencies have you made? What lines of like authority have you created? And this becomes very important for how durable a change is going to be. So here's a big, like, kind of, let's call it a European example, right? people sometimes are quite shocked at how quickly the Keynesian settlement, seeming very durable, just collapsed. One of the reasons it collapsed so quickly is because it's something that came from above, from governments. It involved people on various levels at various alienated. And that meant that the kind of subjects that were created in the context of Keynesianism were not necessarily the kind of people that could defend Keynesianism in the same kind of way. Right? Someone made a different decision to go about this, da, da, da. So there's a question, the way in which you go about achieving things is also politically important. And that's not just an added extra. Like if you're trying to build something different, the way in which it's built and what gets created afterwards is really important. So I think a lot of what's being said here, I almost interpret in that way, which is like, well, what kind of change do you get by taking a certain method is actually really important, both for the durability of the settlement and also from what you create after it, right? So partly then what I'm thinking about some of the limits of this stuff is that these limitations get built in even when you win, and you very often don't win, right? So then what are some of the things that I've picked out and we've already discussed? Well, I think the first thing, right, is international law is already, in broad terms, like a set of practices which are alienated and distanced from most people's lives, right? Like all legal arguments to that, it's to some degree, are already there. They're conducted in like a kind of archaic, inaccessible language that you need to have a degree to talk about, and all this kind of stuff, right? So, because one thing I was actually thinking as a slight tangent is that one thing that interpretation is always it's an act of translation. It's taking like someone's position and it's translating it into a language of law so that you can make those claims, right? So in this alienated normal law thing, we then come to not just treaty law, which at least you can see a line. It's like, here's my executive, I voted for this thing, and here's the treaty. It's like, oh, here's this like, whenever you tell anyone about it, really strange thing where people are like, wait, what? The state's will? What are you talking about? But also one that feels incredibly inaccessible because it has this kind of relatively arcane thing where you can't draw lines from X to Y. So it's kind of very alienated mechanism of doing politics, very distant. And I think that's not unimportant. So that's an important limit. The second thing, as we've already discussed, right, is that it is like slow, because of course, like we're dealing with glacial pace of changes. We're having to make these kind of arguments. Maybe you have to violate, maybe you don't. Like, so you have this very like slow and draggy thing in terms of the change, right? Combine that with then a third point, which is that because of this inaccessibility and because of the speed, you just have to go to lawyers, right? Like this is a way of translating people's interests in various ways into this legal language, going up the alienated chain to make an argument which many of the people that are trying to make the argument might be a bit confused about, not just because they're like not smart, but because actually you're having to make incredibly twisty arguments just to make something make sense, often acting in bad faith. So we have a situation which in some sense can be very problematic in terms of the kind of agencies it creates and the kind of relationships that it does. That's not an automatic limit, but it does mean that if you're thinking about the relationship between customary interpretation and social change, you'd have to go so many ways to try and mitigate what are clearly intrinsic and inherent possibilities, but continually creating essentially relationships of almost like dependence between like marginalized and other groups, or whoever's not trying to make this, their lawyers, the courts, all these kind of things. And that's not necessarily a good or like useful way of doing politics in a durable way. So alongside these kind of broader other structural critiques about the embeddedness of customary international law in a set of relations of like exploitation and domination, we also have this. I think of these as kind of being like more like specific limits to the nature of customary international, right? Because again, customary international law, it's weird. People have a difficulty working it out. But beyond that, right, I think there's also a set of deeper structural things beyond simply the way in which customary international law is embedded in the world. And part of that is that I think that in some sense, customary international law brings with it, whether or not you want it to, a certain kind of social ontology about how the world works, right? Because we all know this. We read about customary international law and it's like, well, we're looking at state practice and opinion jurists, a weird personification of the state comes up. But customary international law is premised on conceptualizing the world as a collection of states who operate as relatively black boxes. It doesn't tend to inquire into what people are doing inside of those states. It just takes the state as a representative of whoever else is going on inside of it. And it kind of imagines that they have a set of quite harmonious interests because it's like, well, if everyone could just agree on this universal practice, everything would be great. Now, for me, that is a social ontology, which is obviously completely wrong, but it's also a very depoliticizing social ontology. It imagines that problems of social change are not necessarily about clashes of interest, which can't be resolved, which have to be resolved with someone losing out, but instead it's like, hey, everything will be good because all these states, it turns out they've all done the same thing. Right? So politically, I think that whole language, that whole way in which it's conducted can be extremely problematic. Now, if you take all of that together, what this suggests to me is that alongside just the simple effectiveness problems, we also have a case for saying that the interpretation of custom in this way brings with it great dangers in terms of how people see and engage with the world, in terms of how we politically constitute people. So that even if you get a lot of things that you want coming out of it, nonetheless, what you create is a political subjects, political actors, and all these kind of things, which is not necessarily where you want things to be at. So in part then, this is the thing I will come back to again, the challenge is in what ways can you mobilize these resources without, as much as possible, like falling foul of these quite natural problems that come with the form that the legal argument takes. And part of that, right, I always think, is about the degree to which you can, and but then, I'm in a room full of lawyers, people don't like this, but like openly and directly subordinating this kind of language of interpretation, like to politics, to being like, well, okay, we're saying this because we have to say this, but obviously the real reason that we're doing this is this. Mobilizing not around the idea of it's like, well, guys, don't worry, the law is on our side, but like, okay, this is the thing we're going to do because this might give us an avenue in. So at least in that sense, in subordinating things in that way, what you can get is a sense of getting out of those kind of problems and also being ready at certain points to just do something else, right? Because actually it just doesn't work. But those limits aren't little, they're very big, and they inhere very much in that specific legal structure as far as I can see. 10 page.
And your 10-page
Question one.
questions. Yes.
So just to start again with question one.
With question, yeah.
Let's accept everything else, we can now reach the proper totality of these answers. And I could say
we could have put it on two times speed. So I was wondering, Robert, I mean, because in question 3, you actually mentioned this issue of bad faith interpretation. Would you consider that also as a part of the limits there?
not really, because I think because it depends on what kind of critique you're doing.
Yeah.
For me personally, it makes no difference if someone's making something good or bad faith argument. Who cares? Like, if they're making political arguments, they're fitting into the form of what they're doing. So I actually think in some ways it's politically much better to make bad faith arguments and make them openly bad faith, because that's part of the way of getting out of these like broader problems of being seduced by the kind of depoliticized normative nature of the law. So it's good for me, but I think for people who maybe have a commitment to explaining how interpretation works in a non-political way as a kind of like a particular thing of legal reasoning, this becomes a problem. Because how do you draw the line? Like we were just saying earlier, like how do you explain in terms of customary interpretation all of this war on terror stuff, where it's like, it's pretty obvious the US wasn't looking around and being like, well, I think all the other states agree with something. Yeah, we can just do that. The US legal arguments were not being made in good faith, but nonetheless, they were authentically interpretation in the sense that they were making them in the language which other lawyers would use in that way. And that can become a very difficult system to break down internally to these kind of normal elements. But for me, bad faith is great. I love it.
And I think that's a resume. That's the sentence you can close on. Johannes.
Yes, thanks. I did a bit the same as Luíza in the sense that I sort of interpreted the final question in light of what I said in the third question. So I interpreted as follows: what are the potential limits of international courts advancing progressive interpretation of custom in order to develop international law? So I hope that's still an interpretation and not a modification, but I will go for it. Go with it for now. So I think there are. I would like to mention three limits. I think the first one is questions of legitimacy that I mentioned already before. Do we really want these specific bodies to develop international law on issues that are clearly dividing states and also the international community? And then I have two limits that are a bit more practical, maybe. The first is pushback by states. I think what has happened, and that's in that sense the minimum standard is also an interesting example, is that arbitral tribunals were having a great time, at least if we take the claimant's perspective in developing the minimum standard and in interpreting what this standard actually means. What then certain states did repeatedly was issuing, this happened at least in the context of NAFTA, the member states issued an interpretation, a notice of interpretation saying, well, the minimum standard, at least under NAFTA, actually means this and this, which was quite different from what most tribunals have been doing so far. And in the newer version of NAFTA, the USMCA, the minimum standard is still there. So the reference to the customary minimum standard, but it comes with a whole list of also limitations and interpretations to sort of restrain arbitral tribunals from what they had been doing. So the same happens, I think, on a sort of larger scale, also in the form of backlashes against these institutions. More generally, we've seen quite a few of them in the past years against WTO. Now, I don't think the appellate body of WTO has been working a lot with custom, but you can imagine that a progressive or a push for progressive interpretation of international law by these bodies would have similar results. And I think that also has happened in investment arbitration very clearly. NAFTA has come under a lot of criticism, partly because of these progressive interpretations advanced by tribunals. And I think the same goes for the way that a number of tribunals ruling on the economic crisis in Argentina have dealt with the necessity defense under customary international law. And there as well, there has been a huge backlash against investment arbitration. Now, I won't say that either of these approaches, the one favored by tribunals at some stage or the pushback by states is good or bad. But what I think it shows, and Robert also made that point, that certain results or certain outcomes also would have to be a certain durability if we really think they are something good. So I think we just, or at least international courts just shouldn't overcharge interpretation in attempts to develop international law.
Thank you very much, Johannes. And you started your answers in question one with the reference to if something is clear, you don't need to interpret it. And in this final question, I think all four of you interpreted the question in a particular way. So I think we came full circle. So thank you all very much. I'm not going to abuse my power as a chair anymore. So I think we'll open it. It's 3:30. So I'm going to abuse my power as organizer. So the idea is that this panel would last an hour and a half. But the previous panel started earlier, we started later. So I think for reasons of equity, we can reasonably give some time for questions to the audience here and online. So anybody in the audience want to ask any questions?
Actually, I'm not sure. It is probably a question. It is directed actually to Robert, and I find it fascinating the idea of the field, which you use in pretty much as a sort of either in a mathematical or physical sense, like as a space in which essentially rules of identification or interpretation are essentially coordinates. It's a coordinate system, right? And this is epistemological, has epistemological implication, that you can have at least a coordinate system in which you can locate a specific argument and assess at least its plausibility in a sort of mathematical or even physical sense. Like if we use the idea of the field on the one hand, and on the other hand, and this is the point of disagreement with Panos, is the strategic and the tactical. So your last comment was essentially strategic, right?
Yeah.
But also it is tactics, as well. Interpretation can be used as a tactic. So to me, is there an intersection between these three concepts? Can you find some point of contact, or are these ideas completely disparate? We need to keep them separate.
I mean, I hope I can find some intersection. I'll spend like 5 years of my life to should I go or say wait or?
No, go ahead.
So I think that's a really good point. And like, so one thing I always want to be careful about fields and stuff like that is since I don't like logic, I don't want to overextend too much this kind of thing. I think fields can be useful for explaining exactly as what you've said. And I think you actually put it very well, which is that how I would understand like this field is also like, there's like a very loose set of things, like, was it Gary Simpson called it like the laugh test, where he was like, sometimes someone will make a legal argument, and I just think there's usually a plausible legal argument right away, but there are some things where it's just like, and you kind of have a rough thing about that. But at least what I've always tried to think about tactics and strategy right is, so it's a temporal question, because the thing is that tactics and strategy always operate in the same temporal space. They operate with, I think, a different temporal logic usually, because strategy is like a longer thing and tactics is a shorter thing. But unfortunately, like everything in strategy is also made up of tactics, right? So my big problem, and this is like what I would say, I've always said is like the distinct thing about like the Marxist tradition is it understands that like tactics and strategy can't be held separately to each other. Like the idea of tactics has to be framed within the idea of strategy. So it's like, because every bit of strategy is just made up of an accumulation of tactics, you could just be like, I'm being tactical, I'm being tactical, I'm being tactical, I'm being tactical. Oh, it just turns out I've just gone completely against what I wanted to do, right? So then the question is exactly, it's bringing them into relation. And so this then comes back into this field question, because to me, what I say is like, if you understand this field as a conflictual one, because of its conflictual nature, that is where you get the tactics. That's where you can do X, Y, Z thing. But it nonetheless, and this is where some people disagree, some critics disagree, it has limitations, a logic, like I would say like structural homologies with other things. That is the limit, and part of your strategic aim has to be to overcome those problems and go where else you're going to go. So for me then the question is, or the thing that would always happen is that then the tactical intervention has to be framed in such a way that it's not ultimately undermining the strategic goal, and also ideally in some way that would like would support that. So the classic example I usually use is like in Rosa Luxemburg's Reform Revolution, right? The thing that she says is, sorry, but she says the thing that differentiates the reformist from a revolutionary for her is that like they both do the same things, but the reformist is like, this is the end goal, this is what I need to do, and the revolutionary is doing it with a broader thing in mind, and that affects how the practice works, because you'll do things differently. There are things you won't do. There are things you'll be like, well, this might be effective for this moment, but it's not going to be effective for what we want to do, so we're not going to do it, and it's going to change the form in which that practice appears. So for me, that is how you bring them together. And I do think the interesting thing is that if we look at certain historical documents, it's very clear that legal actors have attempted to mobilize legal arguments in non-traditional ways, aware of the limits of what they would do if they went like too far with it or led into it, and have tried to do that with greater or lesser degrees of success. So I think it's possible, but obviously it's not easy. But then the other thing I also think I always like to say, right, because it makes perfect sense to me, like we work in a discipline, and that discipline is significant to us. We like to imagine that that's like the entire world, and it's not. Like sometimes you can just be like, you know what, you'd be better off spending your time doing this thing than like pursuing a thing in like and sometimes that's actually my final point is sometimes a valuable thing that I think people can do as like legal scholars or practitioners is if they're approached by people who are like, this is definitely going to like help us, is to go, yeah, it's probably not. And actually maybe you want to take your money and do something else. Like, because like, you know, I know a lot of like activists who are basically like, so if I have the law on my side, like just definitely going to win this. And it's like, but yeah, so I think you can bring them together, but obviously it's difficult. That's always why I try to do it. Does that make sense?
Yeah.
No page 10. Shame. This thank you very much. This question was addressed to Robert, but if anybody wants to chip in, you're more than welcome. No? Okay. Anybody else from the audience? Andre?
Yes, I want to get back to the week. Now, I know, of course, that the week was initially in the first panel, but I think it comes up here because the first question raises the issue of domestic litigation. And I think the final question, at least as interpreted by Johannes, raised the issue of development by international courts and tribunals. And of course, when we talk about identification of rules of customary international interpretation, etc., in principle, everybody identifies, everybody interprets. That counts for all of us. But the issue is, of course, what kind of weight or authority persons have in actually doing so. And of course, I'm a very conservative positivist, so I'm thinking, of course, when we talk about customary international law, about constituents, which in principle we say is states. And the International Law Commission has been courts. Nominated by states and, even if acting independently, but listening very carefully, of course, to the legal advisors in the Sixth Committee. They've been very conservative in, for instance, not giving a role to international organizations when it comes to the development of customary international law, for instance. So the constituents, we say at states, and that all falls within the paradigm that international law is created by states. And then we go to courts. Now, at the international level, at least the ICJ has suggested that it cannot legislate, even if it has to note the development of customary international law in certain circumstances. And of course, generally, in most contexts, international law applies the civil law model of cases only being binding on parties to the case for that particular case. So no system of precedent, etc., which of course limits the weight, whether of identification or interpretation. Now, for domestic courts, it's a little bit further even, because even if they interpret, they don't actually speak for the state. Their decisions may be attributed to the state, but when it comes to who actually represents the state in international relations, it's not the courts, it's the government, and not parliament included, but just the government. So that also means, in that particular context, the weight of whatever identification or interpretation takes place must necessarily be, less strong. You might say, well, way less, you might say, than when states through their governments take certain positions. So I thought I'd just draw your attention to that, because those also go to limits, of course, to some extent, of who we actually listen to. And of course, in principle, everybody can listen to everybody, which actually is also to a large extent what happens. But it's, of course, what kind of weight you're going to give to the argument being made in favor of this or that position.
Anybody? Yeah, Professor Çalı.
Thank you. I just wanted to pick up on 2 points. I think you raised, not all of it, I think you've raised quite a few interesting ones. The first is about the International Law Commission's position on the role of international organizations. And I do find myself on the group that is not very convinced by that position. Just wanted to put it out there, because it's just, is empirically a very tough thing to do, because the international organizations are in an incredible crucial position to actually state or confirm or declare customary international law. And these declarations are, they can come from different levels or different forms and shapes, these practices, and it's very difficult to box them into the state practice opinio juris paradigm afterwards, or repackage them in that kind of way. So I think we're missing something from the empirical world or the practice. So I think this is kind of the shell of the doctrines are not fitting the real practices any longer. And I think that's a bit of a problem, given the empirical nature of custom, if we're really into the empirics of it. Just on the second question about domestic courts. So if a country's constitutional court is empowered to interpret their constitution, and their constitution asks them to take into account or declare a position on customary international law, right, as a matter of domestic law, that decision of the Constitutional Court will be binding on its executive. So, so then if, we have executives who disregard their own constitutional courts and go to the UN or what have you and say something exactly the opposite, I would have a bit of a doubt to say that, the executive's position would count more than its constitutional court. So I think we might have to think about this a little bit more integrated as to the relationship of these organs internally as well, because they are not sort of isolated from one another, but they're also in some sort of a authority relationship. So I would worry if we said, oh, this is what a constitutional or a Supreme Court said, but let's say what President X or whatever the practice A says about it. So maybe something to think about, this integrated aspect, the internal and the external dimensions in the roles of courts in that context. Thanks.
Okay. No, please go ahead.
On the ILC point, I think that was really interesting because, and this is something I meditated a lot on because the first conference I ever went to was about the Customer International Law project at the ILC. And I was a first year PhD student and I was in the same panel as Michael Wood, who was special rapporteur, which was terrifying. And I think what is most puzzling when we're talking about the ILC's argument that, IOs in general and their organs specifically don't have as key a role as in practice, as Professor Çalı mentioned, they might have for all intents and purposes of formation, is that we're discussing the ILC's position in the first place, right? And I mean, we're almost using the ILC as a proxy again for customer international law being an organ of an international organization when we're having the argument. So I almost think that kind of proves its own point in a weird way. And I do this all the time as well, which is that I think the theory and the reality of how these things are formed and how authority is built is really tricky. So it's really tricky for us to separate how we actually conceive of things happening and the authority that these organs have for one reason or another, and the way in which we think that they themselves say that they don't have. So that was just yeah.
Okay. Sorry, Voter. I see we.
Yeah, there's only one question, and actually it came a bit earlier in the discussion, so it will bring us back to the previous question. So I believe that it would be wiser to just give Wouter the floor at the moment.
No, just checking how many questions there are. Okay.
Are you sure? Because I think indeed this question was earlier. So.
No, only because it will kind of bring the discussion back to a different point. So I think it would be perhaps wiser to keep now on this nexus and then we move in the different direction. Okay.
Yeah, thanks everyone for the presentation. It's really interesting to hear the discussion. I'm not sure whether I can formulate my question very well, but I got stuck on this idea of tool, where I think somehow for me it doesn't fit. I think somehow it misses what goes on when you invoke customer law, and it might have to do with this we idea. So of course you can say, well, I'm going to use it just to achieve a certain end. I think it's always that case, not that this is out of just fidelity to the law, right? You always have some kind of project that you're in. But at the same time, I think especially with customer law, what you do, and I think the discussion on does the practice of international organizations counter not attests to it, you always put on the table a conception of the community that you think that this law involves. So I think a lot of these foundational debates on customer law are about exactly that. So what is actually the community that is regulated? So how do we know it's only states? I mean, we have a phone line to heavens that tells us, how do we know, right? So you can't solve it empirically. So there's always this political moment, and sometimes you see these breaks. And maybe sometimes even in domestic courts, right, where all of a sudden the Dutch court starts to read things into Dutch law that come from all kinds of non-binding instruments, and of course it's well not binding, okay. But so as I said, I don't know exactly what my question is, but I feel uncomfortable with this term tool because it's always a tool, but it also always misses something that goes on. And I think this we question pops up every time. And why not include other actors? Who tells us not to do so, except for the ones that claim that they are the ones that we should listen to?
Thoughts, suggestions for other terms from tools or musings on we?
I could kick it off or so I think the first point is, and I think this is where I'm going to be like ambivalent, all invocations of law, I think, not just customary law, international law invoke an understanding of the community, right? I think any, like domestic law does too. I think what you've just done here, so in the context of what you've just said, how could somebody invoke customary law even if they were just doing it? Just as in they were doing it very instrumentally, but they actually don't believe in it, right? Because they might call up an idea of a community, which they just have to do, because it's like, that is what you have to do to make this argument, but then also be like, I don't believe in this community. We have lots of historical examples of that, of like, you know, whatever, like think about states that have at certain points invoked, you know, the right to self-defense because they're being bombed by the US or whatever. They're not necessarily saying like, oh, I really love the international community or something. They're invoking it in this kind of partial way, not to create an idea of community, I don't think, but just because like that is the form of the language in which they have to do. And so this is why I'm like, I think for me personally, I think this is possibly just a fundamental ontological disagreement we have about it. In the idea of like, when actors invoke law, they're not always just that, redescribing it may not be what they want to do because they want to win the argument. So if someone is making a custom argument and then they're going, but like, by the way, I just wanted to also add that this local community is doing this thing, they may not do that simply because they are like, given the interpretive space that I am occupying, this will not be as effective an argument in this other way. And what I want to achieve right now is an effective outcome, not possibly shifting the entire pattern of like discourse, right? So I guess what I'm saying is the idea of like the tool thing would be, it implies a greater degree of instrumentality than simply I want to get what I want, but I'm also creating community. But like, it's like the community I'm creating is instrumental. I'm engaging with this community in a purely instrumental way because I have to do this to enter into this mode of argument. But that is what it is. Because of course, I totally get your question, which says, who says that it has to be states? I think the response is like the crushing weight of history and like reality. I'm not convinced that you can just walk in to a juridical space like this, make a completely like different set of actors in your kind of thing about state practice and be confident that's where it's going to get out. So maybe it's different modalities of what people are thinking political intervention is in what kind of context, which is then conditioning what that has happened. That is probably, by the way, I would cast what you were saying less as a positive thing. It's like this is always the problem or the weakness, right? To what degree does invoking this like reinforce the notion of community with which you don't have any truck, but you have to do it because that's the space that's available to you to make the argument. Like, I don't know, like if you were an anarchist and you were invoking international law because they were going to put you in prison, like you might be reaffirming the idea of like the state as a central actor, but you know, you're not doing it really. You're just doing it instrumentally, you're doing it tactically, and you're doing it, I think. And that anarchist might make the decision, you know, it's better that I don't go to prison than that I act in such a way that is completely consonant with my politics and therefore will not reinforce or reinvoke this thing. So on one level, I'm legitimating and calling it to be in this community, but I'm just doing it because it's probably better if I'm not in jail. And I think you can read that up in something too. I don't know if that makes sense.
Does it?
Yeah, in a way, that's what I put them forward, right? If you want to be heard, there's no way you can get around this community idea, and whether you some deep down believe in it or not, that's in a sense immaterial.
But it doesn't have to be deep down. I guess that's kind of what I'm saying.
Yeah,
like you could. One of the beautiful things about like international law is you could literally have like your friend standing outside of the ICJ and being like, by the way, we don't actually think that this is correct, but we're just doing it. And in principle, the ICJ is not meant to go, oh well, now that we've heard that, we're going to like rule against you. So like, there's a split thing there about like the relationship between, about how you mediate the relationship between political mobilization and political messaging, if you like, or political communication, and what you invoke in a courtroom. And in principle, I don't think they have to like coincide entirely.
No, but the court says it's been taken up later on, right? So that enters the system, reinforces the system, and not your friends shouting outside, I guess.
But I'm thinking also of like, I don't know, and then I'll stop because I'm just to listen to the conversation, but I'm thinking also of like some of the stuff that happened with like the FLN in French courts, where they're like, either sometimes they recognize the authority of the courts and sometimes they're not, but even if it looks like they are recognizing the authority of the courts, the FLN is also outside being like, we don't recognize this, but we're just doing this because we don't want our militants to go to jail, right? I think that's a possible mode of at least, on the one hand, invoking the community, because you're absolutely right, insofar as you do it, you have to, but invoking it, I guess, in what way, to what audience, and to whom, and what is that contributing to is a question, right? And if you're thinking of your main addressees not as being a legal community, but a wider like social political community, I think you can have a certain kind of split in how you approach that. And that's the tool thing. Insofar as you go like, guys, we're just doing this because we got it, but don't believe the hype.
I'm looking at anybody else from the panel want to jump in on the conversation?
Yeah, maybe a brief thought on this. I think it also goes back to the way we actually see custom as a sort of more ontological matter. Is it really just, you know, the conduct of states that also happens to have some sort of legal backing behind of, or is it a bit more of a sort of international legal super norm that we, whoever that is, just think is good and right and just. And I think that goes back to the examples mentioned earlier as well of norms that we recognize as international custom, for instance, in the human rights field, even though it's obvious that they are being violated all across the world. And maybe here there's an interesting reason to actually, again, distinguish between identification and the interpretation of custom, because possibly the identification is still very much focused on what states do and what states say about their conduct, whereas possibly the field of interpretation of what these norms mean opens sort of the floor to or enable interpreters to take into account views from other actors within society beyond just states.
Any additions to that or questions from the audience? And then I think we'll move on to
So we have received one question, which came a bit earlier in the discussion, so I think it will bring us back a bit to our previous questions. But it is a question by an anonymous attendee. And again, as previously, I will read it in full. Would it be fair to say that customary international law, as it has been interpreted hitherto, safeguards the interests of the global north, and does it naturalize and validate Western assumptions and preferences?
who wants to give it a try?
Perhaps I can come back to it briefly. I don't know if the attendee is still with us, but it depends on which customary international law, right? So I think this is an interesting aspect of it, and I think there is obviously some really wonderful scholarship, especially from the tradition of third world international law scholars, who have made this argument in relation to rules in the decolonization period and how custom was used actually to delegitimize some of the more, let's call it progressive again, I don't know if that's the right word for it, some of the claims of the new states. But I think the question really depends on which norm and who interprets it, where, in what context. But some of the bigger structural norms, the as you were principle, the uti possidetis and what have you, I think there's a lot of scholarship that kind of underlined those aspects. Also the rules, I think Robert mentioned it, how you make customary international law. There was a big push about that and literally kind of trying to really decenter Article 38 of the ICJ and bring a lot more legitimacy to the General Assembly. That also hasn't necessarily succeeded. But these days, I think, if the attendee is still here, have a look at how the Inter-American Court of Human Rights interprets customary international law, or how it's being interpreted in different places. So I think it depends on who is interpreting which norm and which historic era or which periods you're focusing your attention to. And maybe just to go back to the previous question, I think customary international law is always an argument. That's the only way I can handle it, that it's just an argument. Somebody makes an argument about customary international law. And as we talked in the earlier session, and then there are takers of it, there are adapters of it, and there are resistors of it. So I'm not so worried that it can be called a tool either. I mean, I think that's not something for me deeply problematic. it's an argument that you make in the context of a very big factual or structural claim. And it's one of many arguments one can make. So maybe you can call it a tool as well.
Any other thoughts?
I have some. I think that's kind of the $1 million question, right? And I think that goes to the first panel as well, which is, do we look at it as a conversation of actors over time? Or do we look at it as a series of snapshots? And I think it's kind of more the latter, but also both. So let me explain. That was a very convoluted way of saying it. So does it always perpetuate or safeguard the interests of the global north and validate their assumptions and preferences? I think according to my previous contributions, I would say not necessarily. I would also say that it depends on if you take the snapshot approach, and which has in a way been used as, for the lack of a better term, a tool of people who believe in as in international law as an instrument for progress, to say, for example, sure, we have, unfair moments, but then we have the Nicaragua case or we have, the Namibia opinion, where actually it was deployed in the other way, or that it was used, for this progressive cause. But then the question is, do we stop counting? Do we stop counting the existence of that rule, or that in that particular moment of quote unquote victory in a way, or do we keep looking at the ways in which either that particular legal development has led to problematic consequences in practice, or not, right? Or perhaps less desirable ways in which we talked about before. Johannes mentioned the connection between human rights and the minimum standard, right? So this idea that sure, we had, this idea of progressive human rights protection of individuals, and then how that was in many ways deployed for and used by investment protection in ways that have had unintended, perhaps some would say intended, consequences to the global south later on, allowing for individuals to have access to, ways of stopping certain countries from nationalizing their assets or whatever. So I think that it's it depends on how you look at safeguards to the global north's interest as a conversation over time, or as particular snapshots of progressive moments in history.
I think nobody else has any further thoughts, or if there are, I think we're going to continue them over dinner, which is not going to be recorded. So please join me in a round of applause for our speakers. So Çalı, thank you very much for joining us online. I think now we have half an hour for coffee, and then we resume for a very, very brief closing. Yeah. Okay.
So for our participants online, we will be back in approximately half an hour for a very brief concluding remark, just to kind of sign off with the workshop.
Robert, the chess player in me wants to disagree. So.
Thank you everyone for coming back. This will just be a very brief closing session where we just want to express our gratitude and summarize very briefly what was done today. So firstly, once again, thank you to all of you who made the trip here, and thank you to all of our speakers who are with us online. I would thank also our participants, but I think that more or less our online participants have left us. But in any event, I'm very grateful for everyone who joined us today, all throughout the day at different points in time. We heard many interesting points, and I look very much forward to seeing what publications come out of this. So I'm very much looking forward to reading the contributions by our speakers. On this point, I will reach out to our speakers in the course of next week, and then we will be able to arrange the practicalities of this. Generally, it informed very greatly the research of the TRICI-Law project, everything that we heard here today. So I think it will feed our research and our respective theses for the next 2 years to come. And yeah, I think beyond this, I'm just very grateful that everyone was here. And once again, I would like to invite us all to give each other a round of applause before we officially close today's webinar.
Yeah, I don't have anything more to add. Everybody's tired, but happy. Thank you to the speakers and to the audience, of course, but to the speakers who engaged in such a very interesting debate. As Nina said, with lots of food for thought. So we'll see most of you during the dinner, where we can continue over drinks the discussion. And again, thank you all very much for joining us, also to the audience, and hopefully we'll get to do this soon again, even more livelier with more people live. Thank you very much, and also to our speakers online, if they're still online. Otherwise, I'm being recorded, so they can see. Yeah, so round of applause was given. Round of applause can be given. Me as well, who wasn't made up. Thank you.